Alright, here we are in Moonee Ponds with Truth Van Lisha in front of this rapist office here, Bill Shorten. I've got a presentation to give today. I'm going to be issuing 5 warrants for arrest. I'm issuing 5 warrants for arrest for rapists, government rapists. It's going to take about 15 minutes, so I've prepared it all and then I'm going to publish it on my social media. So here we're in front of Bill Shorten's office, the rapist. 29 March, Friday the 29th March, 5 arrest warrants issued today in front of this rapist's office, Bill Shorten, Moonee Ponds, the member for Maribyrnong. I refer to the already published evidence on my YouTube channel and any other private and public evidence already published and provided, especially from the rape victims themselves. The charges are rape under the following legislation and rape and manslaughter for one of the men and sexual harassment and manslaughter for another under the Crimes Act 1900. Sections 15 and 18 and other applicable manslaughter legislation. The powers of arrest are stipulated in the Crimes Act 1914, powers of arrest by police constables and by the people, with or without warrants, under sections 3WA, 3Z, 3ZA, 3ZB, 3ZD. So the people can arrest those rapists as well as the police. Bail is not to be granted under section 15AA, Crimes Act 1914. The first arrest warrant is former New South Wales policeman Tim Hill for the 25th September 1996 rape of New South Wales woman Kerry Hawkins. The evidence first published on my YouTube channel the 14th of August 2014 and the second video published evidence on the 19th of March 2018. Put the links in the video description of this video. The public and police can download those video evidence and any other published video and written evidence for arrest and prosecution. There is evidence on those videos of 6 letters from John Howard's office and roughly 15 other politicians and senior police officials proving they all had knowledge of the rape and did and said nothing to arrest or prosecute the rapist. The second arrest warrant is for this federal Labor politician here, William Shorten, for the 1986 rape of Kathy Sherriff at a young Labor conference in Port Arlington near Geelong, Victoria. At the time, Kathy was 16 years of age. Evidence published on my YouTube channel the 25th of August 2015. Channel 7 published some of my video rape case evidence for Kathy Sherriff in their television news across the country during the 19th of May 2019 federal election, where I was a candidate on the Cooper federal ballot. Regarding the issue, following an article from the Australian print publication regarding the issue, there is other evidence published for Kathy's case. The third arrest warrant is for former New South Wales Police Minister and Premier Nathan Rees for 10 months ongoing sexual harassment and manslaughter of a New South Wales woman, Fiona Field. My part 1 video, Facebook video, 11th of August 2016. And my part 2 video, Facebook video, 17th of August 2016. Reading out Fiona's 19th April 2016 private Facebook messages to me before her suspicious death, alleged suicide in her car, on the 29th of May 2016. Sadly, I did not read Fiona's messages until the 22nd July 2016 as they went to my filtered messages. Fiona claimed thousands of sexual harassment text messages sent over a 10-month period sent from former New South Wales Premier Nathan Rees's phone to her phone. Rees was also her local Member of Parliament. Furthermore, her harassment by Nathan Rees, several policemen, the evil actions of Magistrate Tim Keady and several defamatory journalists drove Miss Field to suicide, despairing like so many thousands of rape victims in Australia. I classify this as manslaughter. So when a rape victim kills themselves, that's manslaughter as well. Those 2 videos I made and screenshots of Fiona's messages to me can be downloaded from my Facebook for prosecution evidence. I quote from Fiona Field. I quote from her private Facebook message to me. Quote, Stuart Littlemore QC advised me in writing to approach the Labor Party and ask them to fund a lawyer for me. He said that if they didn't help me, it would come back to bite them. I wrote to John Robertson and Bill Shorten, but I was ignored. I wrote to the Premier Mike Baird, I wrote to the Prime Minister, I wrote to the Attorney General and I wrote to the Governor General, but no one would help me. That's Fiona Field's pleas there for help. Fiona Field was also raped by New South Wales policeman Russell Alexander Marsh in 1989. She was aged 16. He was sentenced to 8 years imprisonment as a result. The fourth arrest warrant is for Christian Porter, federal politician for Pearce in Western Australia and former Attorney General of Australia, for the January 1988 rape of Catherine Thornton in Sydney, New South Wales. At the time, Catherine was 16 years of age. Christian Porter is to be charged with rape and manslaughter because last year in June 2020, in the face of years of her seeking healing and pleading for justice, the victim, Catherine Thornton, killed herself. So the charges for Christian Porter will be rape and manslaughter under sections 15 and 18 of the Crimes Act 1900. I will read out the legislative provisions for rape and sexual assault shortly. In Porter's rape case, the victim's 2013 counselling records are enough evidence for conviction as they are protected under the Criminal Procedure Act 1986, Part 5, Division 2, which applies to New South Wales. Back on the 13th of May 2013, I published a video on my YouTube channel proving that Christian Porter was intent on further legalising brothels and prostitution in Western Australia. So it does not surprise me he was capable of raping someone out of absolutely no respect for women whatsoever, being half the world's population. We have seen evidence of disgusting immoral behaviour, politicians dancing naked on Parliament House tables and procuring Australian men and women for prostitution in the building, bringing further disgrace to themselves and the people they violated for that purpose. The fifth arrest warrant is for the man who raped Brittany Higgins in March 2019, Parliament House building, Canberra. 4 other women have subsequently published allegations of rape, sexual assault and sexual harassment by this man. For the safety and protection of all women concerned and other women, the rape and sexual assault legislation is state by state. Our nation really needs an updated Commonwealth statute for rape and sexual assault. For the police and prosecution, including lawyers, rape and sexual assault legislation, and for the public, I'll do state by state. Australian Capital Territory, the Crimes Act 1900, Section 50 and Section 54. New South Wales, the Crimes Act 1900, Part 3, Section 61, Section 61A to G, which was in force before the 1989 Act. Subdivisions 1 to 4, Section 63, Sections 50 to 72 generally, Section 80 AD, Section 5A1, Section 611, and Schedule 11 of the Crimes Act 1900, Parts 1A, 1B, 1, Part 2, and Part 19. Crimes Amendment Act 1955, the Crimes Sexual Assault Amendment Act 1981, and the Crimes Amendment Act 1989. So all of that legislation needs to be looked at in especially the Christian Porter rape case and for manslaughter as well. The Northern Territory rape and sexual assault legislation. Criminal Code Act 1983, Section 3, Section 192 and Section 192B. Queensland, the Criminal Code Act 1899, Section 1, Section 347 to 349 and Section 352. South Australia, the Criminal Law Consolidation Act 1935, Section 48, Section 5, Subsection 1 and Subsection 3 and Section 48A. I've spent all week researching this legislation. Tasmania, Criminal Code Act 1924, Section 1, Section 127A and Section 185. Victoria Crimes Act 1958, Section 35, Section 38, Section 38A, Section 39, Section 35 to 47 generally needs to be looked at, especially in regards to the William Shorten rape case, Kathy Sherriff. Western Australia, the Criminal Code Act 1913, Section 319 and Section 325 to 326. Protection of rape and sexual assault evidence is the ACT, Evidence Miscellaneous Provisions Act 1991, Division 4.5. New South Wales, the Criminal Procedure Act 1986, Part 5, Division 2. Northern Territory, the Sexual Offences Evidence and Procedure Act 1983, and there's a 2019 Amendment Bill which is still pending. South Australia, Evidence Act 1929, Part 7, Division 9. Tasmania, the Evidence Act 2001, Section 127B. Victoria, the Evidence Act 1958, Part 2, Division 2A. Western Australia, the Evidence Act 1906, Section 19A to 19L. The public can refer to the Australian Institute of Family Studies 8-page appendix resource sheets and also a 12-page resource sheet in that published by the Australian Centre for the Study of Sexual Assault. Also, under this legislation that I've just outlined, the counselling records are largely protected under the law, under those evidence acts, yet there needs to be improvements for the protection of medical examination evidence. And especially this is where a Commonwealth law on rape and sexual assault will be of great value to the women and vulnerable men of Australia and the children of Australia. Rape and sexual assault prosecutions are to be conducted in the district and Supreme Courts, not under any circumstances in magistrates' courts due to limitations imposed on magistrates' sentencing acts. Also, a list of Liberal and Labor politicians will be charged with aiding and abetting these rapes and subsequent rapes under sections 249F and 351B of the Crimes Act 1900. (249F) and 351B of the Crimes Act 1900, New South Wales and Victoria provisions, and Section 181 of the Crimes Act 1958, which is applied within or outside of Victoria. They are also to be charged with attempting to obstruct, pervert and defeat the course of justice under Section 43, subsection 1 of the Crimes Act 1914, because they failed to act on CCTV footage, police investigations, public media questioning and evidence, including evidence that I published, and the victim's years of written and verbal correspondence and from their pleas, the victim years of written and verbal correspondence to and from their pleas for help with politicians and other government people, which went unanswered and ignored, largely. Effective action. This list includes and is not limited to John Howard and his staff, Malcolm Turnbull, Scott Morrison, Linda Reynolds, Tanya Plibiscik, Penny Wong and Sarah Hanson-Young. Over the years, not one of those politicians instructed the police to arrest and charge any of those rapists. As the public knows, their rapist shit goes on for years and not one of those politicians, not one, instructs the police to make arrests and charges. Add this to all their other economic and political crimes, it's simply putrid. AFP Commissioner Rees Kershaw, Scott Morrison's Head of Department Phil Gaetjens and New South Wales Commissioner Michael Fuller are to be subjected to investigation for any attempts to obstruct, pervert or defeat the course of justice under Section 43, subsection 1 of the Crimes Act 1914. If arrests are not made within 72 hours of publishing my video here today, they are also to be arrested and charged. We pray for justice for Kerry Hawkins, Kathy Sherriff, Fiona Field, Catherine Thornton, Brittany Higgins and all other rape victims across Australia and throughout the world. We publicly applaud their bravery and courage. We stand together in the pursuit of the abolition